Why are students, upcoming advocates, judges, and also senior advocates so peeved and anxious about the ratio of the judgment rendered in Suraj Lamp's case, Suraj Lamp's Private Limited versus State of Haryana and another, reported in 2009 Supreme Court 3007. This point can be answered in this way that today we are having a boom as far as real estate is concerned, and the realtors are finding ways and means to avoid payment of stamp duty to the government. And the government has plugged the loopholes and said and also recommended the amendment to the Registration Act 171B was introduced by the Amending Act of 2001 implemented from 1/7/2001, whereby it is said any right to any right regarding immobile property which creates, eliminates, releases, relinquishes or has to be compulsorily stamped and compulsorily registered. So the question is, one of the ways of avoiding stamp duty earlier was getting into existence hybrid documents and also documents which avoids stamp duty in all respects. One of the ingenious ways of avoiding stamp duty is to execute an AGPA, or what is called Agreement of Sale cum General Power of Attorney. Here, what is conveyed or what is sought to be conveyed is an immobile property is sought to be conveyed. And the stamp duty is not paid, the entire sale consideration is not paid. But now it is mandatory that 171B of the Registration Act says even if the lease is for less than 1 year, it has to be properly stamped and the proper stamp duty has to be paid and it has to be compulsorily registered. Even an agreement of sale also has to be registered and stamp duty has to be paid. Then coming to sales, it is said that any transfer relating to immobile property has to be reduced to writing and the entire sale consideration has to be paid. In one of the cases, we confronted this problem and the judge was harping on the Suraj Lamp's case. Here is a case where if the suit for specific performance is filed, what is mandatory is the entire consideration has to be paid, the entire stamp duty has to be paid, and it has to be properly registered. And then alone the document can be admitted as proper document. So now the scenario has changed where you cannot avoid the payment of stamp duty and consideration or registration at any cost. In this particular Suraj Lamp's case, the point that arose before the court was the enforceability of an unregistered agreement of sale /GPA/will. Here, the Supreme Court copiously quoted the provisions of Section 5 of the Transfer of Property Act, which deals with transfer of property inter vivos. That is, transfer can be made only between living persons. Say they ruled out the enforceability of a transfer of an immobile property through a will. So the next question comes, the enforceability of a GPA. GPA is only an authorization given to the power of attorney to sell the property. Here also they said it requires writing, it requires registration, and also they dealt with what is called will also. Will, since will is not inter vivos, it is before the demise of an individual, it is not a valid transfer. So the Supreme Court, in the ratio of the judgment discussing various points and discussions, held that any document which is enforceable in a court of law relating to immobile property has to be in writing and has to be duly registered. Unless the formalities laid down in Section 17(1)(b) of the Registration Act is complied with, the document cannot be enforced. Then coming to the question of 53A of the Transfer of Property Act, which deals with part performance, at the most it can prove the substance of the transaction, but it does not validate the document. But part performance can be claimed as a defense, but not as a ground of attack. That's what the Honorable Judges of the Supreme Court, headed by Justice Ravindran, held. and they also ruled out any interest being created regarding non-fulfillment of the legal conditions which are required for a valid transfer. To put it in short, concluding, we can say that Suraj Lamp's case is a landmark judgment which says an agreement, even though it may be an agreement, even though it may be relating to immobile property, it has to be reduced in writing, and the entire sale consideration has to be paid and has to be duly registered under the law, be it an AGPA or be it a GPA or be it a will. So for the first time, the Supreme Court put its leg down and said all unregistered documents cannot be enforced in a court of law. But of course, the question is, you can distinguish this judgment by saying, suppose the court asks you a question, how do you answer how the suit is maintainable when it is not in proper form? Here you can explain to the court by saying, sir, please look into the document. The sale consideration was agreed to be so and so, and the entire sale consideration has been paid. There is an endorsement in the reverse of the stamp paper that the entire stamp duty, entire consideration has been paid. It has been admitted by the vendor, and also it has been duly registered under the law. The question is, the document is definitely enforceable. This is how you try to distinguish the famous case of the judgment or the dicta of the Suraj Lamp's case. But Suraj Lamp's case plays a very important part. But please remember, don't be carried away by any citations. You must also have the wherewithal how to distinguish the judgment, how to convince the court, sir, this judgment does not apply as far as my case is concerned. If you try to say that, you will have to show, sir, what was the consideration agreed, what was the amount paid, what was the stamp duty that has been paid, what amount has been paid towards registration, whether all the formalities of law has been complied with, whether the provisions of section 54 of the Transfer of Property Act, which says how sale is made, sale has to be in writing, signed by both the vendor and the vendee, it has to be attested by 2 witnesses, and also the question is, you will have to say that whether possession has been delivered or possession has not been delivered, and the title of the vendor has to be clearly mentioned. When you are able to show all these things, and the impugned document and the document which you set up in the court by way of an AGPA, you tell the court, sir, the provisions of section 54 has been satisfied and there is no impediment as far as enforceability of the agreement is concerned. So the question is, Suraj Lamp's case can be distinguished, not that it cannot be distinguished. If you use your brain properly and try to twist the matter by saying, sir, this is how it has been done, the court need not follow the Suraj Lamp's case. For every transaction relating to specific performance, Suraj Lamp's case cannot be cited before a judge. And even if the judge has got a lurking doubt regarding this interpretation of Suraj Lamp's case, you can definitely succeed if you are able to show the court these are the various circumstances, these are the various facts, the document speaks so, the spirit of the document speaks so, the interpretation of the document speaks so. So the question of Suraj Lamp's case does not apply as far as my case is concerned. The observations made by the learned judges was to interpret, saying that the AGPA, GPA as well as will is not an effective document. It's not a concluded document. You require a concluded document which shows vis-a-vis the title of the party, and only those things can be enforced in a court of law. That's all as far as the judgment of the Suraj Lamp's case is concerned.